Welcome back to City Education, your home for education in all forms, shapes, and sizes. Today, we journey back into the world of environmental law, exploring the right to development and how it interacts with the right to a healthy environment. Development and environmental protection are both third-generation human rights, which means they focus on collective progress and the well-being of communities. In our fast-changing world, improving living standards and safeguarding the environment must go hand in hand. Understanding these two rights and their balance is vital for building a future that is both prosperous and sustainable. In order to understand the right to development, we must first ask, what is development? Development goes beyond buildings and roads. It is a people-centered process of change. As defined by Skippers, true development depends on people's capacity to manage progress through critical steps that lead to meaningful, lasting improvements in the quality of life. It is deeply connected to socio-economic rights, like access to housing, education, and healthcare. Governments are obligated not just to create opportunities, but also to justify their actions and avoid hindering these rights. At its core, development means empowering communities to thrive in a peaceful, stable, and well-governed environment.
Now, there are two core views of development, which is the traditional view of development and the modern view of development. The traditional view of development focuses primarily on economic growth, building infrastructure like dams, roads, and schools, as well as driving policies that boost material well-being. But this approach is narrow. It often overlooks environmental costs and the social impact of development projects. In South Africa, we see these government programs like the Reconstruction and Development Program, which is RDP program, which aimed to uplift poor and marginalized communities by improving living standards. While it achieved socio-economic gains, environmental concerns were sometimes neglected. A case in point is Wildlife Society of South Africa versus Minister of Environmental Affairs. In this case, authorities allowed shacks to be erected on an environmentally sensitive coastline. The court ordered their removal, exposing the damages of prioritizing short-term economic benefits over long-term environmental sustainability. This view reminds us that growth without environmental consideration can create problems that undermine the very quality of life development aims to improve.
Now let's move on to the modern view. The modern view of development takes a holistic approach. It recognizes that true progress integrates economic growth with social, political, cultural, and environmental well-being. This approach is grounded in the idea of sustainable development. Development that meets today's needs without compromising the ability of future generations to meet theirs. Environmental protection and human rights are no longer separate issues. As Oliver J. stated in the Save the Vaal environmental case, environmental concerns must be given appropriate weight in all administrative decisions. In Fuel Retailers Association versus Director General Environmental Management, the Constitutional Court stressed that development cannot exist deteriorating environmental base. Protecting our natural resources is essential for lasting economic, social progress. This is why South African law, through NEMA, which is the National Environmental Management Act, requires development to be socially, environmentally, and economically sustainable, a reflection of a world where human well-being and environmental health are inseparable. In South Africa, the modern view of development is firmly rooted in our legal framework. The National Environmental Management Act, NEMA, sets out that all development must be socially, environmentally, and economically sustainable. Decision makers are required to take a risk-averse and precautionary approach, especially when the consequences of a project are uncertain or cumulative. The Municipal Systems Act strengthens this by defining environmentally sustainable development as providing services in a way that, firstly, minimizes harm to the environment, human health and safety, secondly, maximizes potential benefit for communities, and finally, complying with all environmental protection laws. These principles reflect South Africa's commitment to sustainable development, a cornerstone of international environmental law since the 1972 Stockholm Conference. They recognize that development and environmental protection are not opposing forces. They are independent and mutually reinforcing. In closing, South Africa's journey in environmental law shows a clear shift from the narrow traditional view of development to a modern sustainable approach. Today, development means more than economic growth. It's about uplifting communities while safeguarding the environment for generations to come. Our codes and legislation emphasize that development cannot thrive on a deteriorating environmental base. Protecting nature is not a barrier to progress. It is the foundation of lasting prosperity. As future custodians of our planet, we embrace sustainable development, balancing economic ambition with ecological responsibility. Join us in building a future where people and the planet thrive together. Like, share, and subscribe to City Education for more insights on environmental law and more legal education.